Hello everyone. Today in this video we are going to discuss about few miscellaneous topics related to general meetings under the Companies Act 2013. In our previous video we have already discussed about the provisions of annual general meeting, extraordinary general meeting and quorum of the meetings. So apart from those important topics, there are few other miscellaneous small topics which I thought it would be helpful to be discussed and to be analyzed in detail. So let us proceed with that. Starting with the first topic, which says that the special business and ordinary business. Now, what does special and ordinary business means? So, I have already discussed it in my one of my videos earlier, but I thought it should be discussed again, and so that more clarity can be obtained in this regard. First of all, what is ordinary business? So, in total, according to Companies Act 2013, there are four types of ordinary business which can be transacted only at the annual general meeting. So as you can read that in case of annual general meeting, all business shall be special business except the following ordinary businesses. So now the consideration of financial statements and reports of board of directors, declaration of dividend, appointment of director in place of those retiring, fourthly, the appointment of and fixing of the remuneration of auditor. So apart from these four businesses, all other businesses in an AGM will be considered as a special business, and these four will be considered as ordinary business, but these can be transacted only at the AGM of any company. Okay. Now, secondly, in case of extraordinary general meeting, it means that all the businesses which is transacted in extraordinary general meeting shall be the special business. So, I hope this distinction is clear as to what is a special business and what is ordinary business. One of the things you need to note is ordinary business are only of four kinds and it can be transacted only at the AGM. All other kinds of businesses are special business. Okay, let's move forward. Our second topic is we have read about the notice of meeting, that is notice of general meeting. So it is covered under section 101 of the Companies Act 2013. Now basically for a general meeting, how many days notice is required to be given as per the act? So you'll be seeing here that we need to give at least 21 clear days of notice. Okay, and it can be either in writing or in electronic mode. Now, one more thing, that what if a company wants to hold its general meeting by giving a shorter notice, that is by giving a shorter notice then of 21 clear days. For that the company needs at least, that is 95% of members consent, and that consent can be either in writing or in electronic mode. So it is the minimum, that is 95% of members consent needs to be given, and those members should be entitled to vote in a meeting. Okay, so the consent of not less than 95% of the members. Now here of the members means of the number of members, and we are not talking about the share capital. Okay, so it is 95% of the number of members. If those members give their consent either in writing or through electronic mode, then a company can hold its general meeting at a shorter notice, that is by giving a shorter notice than that of a 21 clear days notice. Okay, now secondly it says that the notice shall specify the place, date, day and hour of the meeting, and shall contain a statement of business to be transacted at such meeting, so that the shareholder should also know that what business is to be transacted in that meeting. Moving forward, we see that the notice, now to whom this notice is to be given. First of all, every member of the company, legal representative of the deceased, or the assignee of any insolvent member. Secondly, the notice needs to be given to the auditors of the company, and thirdly to every director. Okay, so first of all, members, notice to be given to the members, which is necessary because it's a general meeting. Secondly, it needs to be given to the auditors, and thirdly to the directors, that is every director. But one more point is given in section, that is section 101, which says that if there is any accidental omission to give or not receipt of that notice by such member, so it would not invalidate the proceedings of the meeting, but that omission should be accidental. Okay, it should not be deliberate, it should not be planned, but it should be accidental. If any accidental omission is there to give the notice, or due to some reason the member cannot receive the notice, then in that case the meeting cannot be invalidated by just this reason. Okay. So next topic is we now have to discuss that statement to be annexed to notice. So again, section 102, that is 102 of the Companies Act 2013, actually prescribes or actually gives tells about the statement that needs to be annexed to the notice. Now it says, the section says that for every special business that is to be transacted in the general meeting. So mark my word, for every special business and not ordinary businesses, which means for ordinary businesses there is no need to attach any statement with the notice. Okay. But for all the special businesses that is to be transacted in the general meeting, the notice calling such meeting, it should be a statement should be annexed to the notice calling such meeting, which means now what that statements should cover, or what should be set out in those statement that is pursuant to section 102. Firstly, the nature of concern or interest, which is financial or otherwise, of every director, manager, every KMP, or relatives of the person mentioned above. Okay, so now if there is any interest or concern of any director, manager, KMP, or their relatives, then that needs to be disclosed in the statement pursuant to section 102. Okay, so now this statement is to be annexed only with the businesses, that is special businesses that needs to be transacted, and it should be annexed to the notice which is required to be given for a calling of general meeting. Thirdly, this statement shall disclose the nature of concern and interest of director, manager, KMP, or their relative. Okay. Secondly, it says that that statement, that is explanatory statement, it should contain any other information or facts that could enable the member to understand the meaning, scope, and implication of the item and to take decision thereon. We need to provide the description of the business that is to be undertaken in the meeting so that the member could know what the business is, what the nature of the business is, so that it could impact or it could affect the decision of the members. Okay, so this is to be disclosed with the statement, and that statement is to be annexed with the notice, but only for the cases of special business to be transacted in the general meeting. Okay, now another point, it says that the section also provides that if the business talks about any document, like suppose if there is an alteration of AOA, okay, Articles of Association, so it's a special business. Okay, now for this special business, explanatory statement as per section 102 needs to be attached. Now for that explanatory statement, we also need to mention the time and the place at which the members can inspect that document, that is that altered AOA, Article of Association. So the section also provide if the resolution or if the business that is to be passed, it mentions about the document, any document of the company, then the explanatory statement should also disclose the time and the place for which that document is available for inspection by the members. Okay, so that is a specific point. Now, another most important topic is what is special and what is ordinary resolution. I'm not talking here about ordinary and special business. I'm talking about special and ordinary business. So this we are reading it from our basics of company law. It is provided under section 114 of the Companies Act 2013. So what is a special resolution and what is ordinary resolution? Ordinary resolution means a resolution for which notice is given. Okay, and in that notice it is clear that it is an ordinary resolution first of all, and for which the vote casted in favor is more than the vote casted against that resolution. Okay, which simply means by more than 50% of voting for any resolution, if it is required, then that would become the ordinary resolution. Okay. A resolution shall be ordinary resolution if notice required under this act has been duly given, and where the votes cast in favor of the resolution exceed the votes, if any, cast against the resolution. So if the requirement for any business is that the vote cast against it is lesser than the vote cast in favor of that, then in that case, that resolution would become the ordinary resolution. Secondly, what is the special resolution? If the intention of that resolution is a special resolution, how we'll come to know about the intention? By seeing the notice. Okay. Now, secondly, that notice has been duly given. Now, thirdly, it says if the vote casted in favor of that resolution are required to be not less than three times the number of votes cast against it. Okay, so now number three times the votes cast against them. Okay, it should not be less than this, which means how much majority we require? Three-fourth of majority we require. Now, three-fourth of majority simply means 75% of vote is required. If 75% of vote is required for any resolution to be passed, then that resolution would become the special resolution. However, the intention should be given in the notice, and the notice should be duly given to the members. Okay, so now what is ordinary resolution? Ordinary resolution simply means for if any resolution, if more than 50% of votes are required, then it would become ordinary resolution. However, if more than 75% of votes are required, then it would become the special resolution. Now, people get confused between special and ordinary resolutions and special and ordinary business. So, ordinary businesses are only of four kinds. Apart from them, all are special business. Okay. And there could be possibility that a business is a special one, that is a special business, and it requires only ordinary resolution. Like, for example, if we need to increase our authorized share capital, so it is not covered under the four categories of ordinary businesses. It is apart from them. So it becomes the special business. However, the act or the section requires that the for increase of authorized capital, only ordinary resolution, that is more than 50% of vote is just required. So it become the ordinary resolution. So it is not necessary that a special business would be passed by special resolution only. Okay, there are few businesses like appointment of independent director. It is again it is again a special business, but only ordinary resolution is required to be passed for that as per this action. Okay, so now another important point is quorum for the meetings. Now we have already discussed it in separate video about the quorum for general meetings. Here I am only going to discuss about a term like for a quorum of a for calculating the quorum of a meeting, we need to count the persons or the members who are personally present. Now, what does that mean? Now, for a member to be personally present, it simply means that no proxies is to be counted while calculating the quorum. Okay, so now if no proxies is, what is proxy? The question arises. Now, proxy has been defined under section 105. For every member who is entitled to attend the meeting and who is entitled to vote in that meeting, can appoint their proxy. Okay, proxy means if a person is not able to attend the meeting, then any other person authorized in this behalf can attend the meeting. However, the proxy cannot speak in the meeting and it cannot vote except for by poll. Okay. Now, proxy is given in MGT 11 form. Okay. First of all, a person can be appointed as a proxy for 50 members, maximum of 50 members, and holding not more than 10% of the share capital having voting right. Okay, so this is the limit. So a single person can be appointed as proxy for many, but the limit is only till 50 members plus only holding up to 10% of share capital and not more than that. Okay, so first of all, while calculating the quorum we have already discussed in my previous video. While calculating the quorum, The members who are personally present, only those members shall be counted and no proxies would be counted. Okay. Now, secondly, Section 112 of the Companies Act also says that about the representative of the president or governor of a state if they are the member in a company. So now, president and governor of a state, if they are the member, then they can appoint any person as his representative to attend the meeting, and he shall attend the meeting and shall have all the rights of the members. Okay, so this is defined under section 112. Secondly, a body corporate, it cannot attend its meeting, the meeting in which it is a member. Okay, so it also needs to require to appoint its authorized representative. Now, how a body corporate can appoint its authorized representative? Through the board meeting. So if a person is duly authorized by the board meeting of a body corporate and that body corporate is a member of another company, then that authorized person gets entitled to all the rights of the member to attend the meeting in the other company in which it is a member. Okay, so now this is again defined under section 113. So it basically tells that they can be counted as a quorum because they would be considered as personally present member. Why I have written it here is just because that they would be considered as personally present, because even the section provides, or even the section assent to it, that the president or the governor can appoint its authorized representative, the body corporate can authorize its authorized representative to attend the meeting in which they are the members. Okay, so that is why I have explained it here. Now, again, a question arises that a authorized representative can be appointed as such for more than one companies. Okay, suppose A limited company and B limited company. A single person can be the authorized representative for both the companies. However, if only one member remains like this, if suppose for a public company having less than 10,000 members, 1,000 members, it requires 5 members to be personally present for a valid quorum. Okay, so now if those 5 members are body corporate and only 1% is appointed as authorized representative, then that 1% cannot hold the meeting. Why? Because meeting itself means that more than 1 person should be present, at least 2 persons should be there. Okay, so it could be like 4 body corporate can appoint one authorized representative and the one can appoint one, so that the total becomes minimum of 2 members for a valid meeting, because otherwise there would be no meeting. 1 person cannot hold a meeting. Okay, I hope till here the concept. So we are done for today. And if you have liked this video, then please like and subscribe. My YouTube channel is PH Webcam Videos. Do not forget to share and comment on this video. Your comments are valuable. So we'll be coming up with more videos, and there are few topics still remaining as of general meeting is concerned. So till then, take care. Bye bye.